Hello, my name is Sarah Greengrass, and I work at the U.S. Consulate General Chennai as a political and economic consul. I also have a legal background, and prior to joining the Foreign Service, worked as a public defender. That means I was a court-appointed attorney for those facing legal action. This video is part of a three-part series on the U.S. Constitution. We hope the videos will help you get a better understanding of the American system that encompasses the judiciary, and therefore acts as the foundation for the rule of law. Let's watch the discussion between Consul General Robert Burgess and Advocate Geeta Ramaseshan.
I'm excited to talk about the U.S. Constitution. You know, as school children, we all studied the preamble, which begins, "We the people." And those are words that have meaning to all of us. And it means that the Constitution represents the people of the United States. And the U.S. Constitution has been a remarkable document. It's a document that saved a struggling new nation. It brought compromises between the mercantile class and the agrarian class, between big states and small states, between those who feared the power of a central government and those who thought we needed a strong central government to protect rights and liberties. The U.S. Constitution has stood the test of time. Its few words, its structure, its principles enunciated have lasted 230 years. And there have been very few amendments or changes to that language over the years. It's really a remarkable document.
To start at the beginning, the American Constitution is considered to be one of the oldest written constitutions. And like other constitutions, has had a very interesting checkered history. So could you tell me how the color of the time was when the Constitution was created?
Sure. The U.S. Constitution is a product of many influences and of the color of its time. The United States was formed out of a revolution of 13 colonies against Great Britain. And many things drove the colonies toward rebellion. One of the driving forces was the idea of taxation and the principle of taxation without representation. The colonies were not represented in the British Parliament, but they felt they were suffering under taxes, whether it was the Stamp Act or later the Tea Act, which provoked responses amongst the population. The Tea Act, for example, levied a high duty on imported teas. And this provoked a reaction amongst the citizenry. Many in Boston, citizens dressed up as Native Americans, boarded ships carrying tea, and in an act of defiance dumped the tea overboard into Boston Harbor. And this became known as the Boston Tea Party, a famous event in U.S. history that was a precursor toward the Declaration of Independence and the U.S. Revolution. After the Treaty of Paris, which ended the war and granted independence to the 13 colonies, the 13 states of the United States operated under Articles of Confederation, which was a fairly loose arrangement with a Congress, but no executive and no central authority. There were a number of leading thinkers of the time who thought that in order to preserve this union of 13 states, there would need to be a stronger central government or central authority. Amongst them were Alexander Hamilton in New York and James Madison in Virginia. And so they proposed a constitutional convention, which met in 1787, to discuss the plans for either an amendment or change to the Articles of Confederation or a new constitution to establish a greater, stronger union amongst the 13 states.
And one of the, I think, the very fascinating part of the history of the U.S. constitutional law And one of its very unique features, given the time when it came into existence, has been the concept of separation of powers. How did this actually come about?
I think in the Constitutional Convention, you had representatives from a number of the states. Some of these were small states, some were large states, some were states with agrarian interests, some were states with more mercantile interests. And so they needed to come to compromise and balance between the large states and small states. So you have a separation in a way there between the interests of balance between large states and small states. James Madison, who's often referred to as the father of the Constitution, was a product of the Enlightenment and influenced greatly by the writings of the late 18th century in Europe.
The French.
And largely French, but in principles of equality, right to property, liberty, justice, and similar questions. When you go to Madison's home, ancestral home in Montpelier in Virginia, you can see a room that was his library. Now, he had requested from Thomas Jefferson, who was in Paris as the ambassador, to send him any book that he could find on international or comparative law, on legal systems, on constitutions from old regimes and new regimes. And so he had absorbed all of these books and ideas dating back to Roman law and structure, and very much became an advocate for a separation of powers in the structure of government. So hence the United States has three distinct equal bodies. There's the legislative branch, the executive branch, and the judicial branch established under the Constitution.
You know, we actually may take it for granted today, but to think at that period, this was established with maybe all the books coming through the sea, is very, very, to me, it's a very fascinating era as to how these things developed. Now, with this, but how does this serve in terms of check and balance, the separation of power?
The fear, and this comes out of the tenor of the times too, where they did not want any one authority to have too much power. They feared the abuse of power of a too strong executive or a too strong legislative branch. And so in this structure of three equal branches, they worked in their draft of the Constitution, many checks and balances. For example, the legislature can enact legislation, but the president can veto it if he disagrees. But in turn, the legislature can override that veto by a 2/3 vote if it truly wants to enact that legislation. The president nominates judges and justices to the court, but only with the confirmation of the Senate. Similarly, the president can sign a treaty, but it's the Senate that needs to ratify that treaty. The legislature appropriates money and enacts legislation, but it's the executive, the president, that carries out those laws. The courts can review the laws and determine what's constitutional or not, but it's the legislature that helps set the jurisdiction of the courts. So there are many inherent checks and balances within the structure of the three branches of government.
You mentioned review, and the US Supreme Court has been the earliest court, or rather given the time, that has actually developed the concept, or rather that created the concept of judicial review, followed or understood everywhere today. And could you maybe then speak about how this came through?
Sure. Early on in the Republic, there was a Chief Justice, John Marshall, who was one of our longest serving justices on the Supreme Court. And a case before him came before the court challenging the constitutionality of an act. And Justice Marshall wrote an opinion in a famous case called Marbury versus Madison, which established this principle of judicial review. It asserted the court's power to determine the constitutionality of an act or a law, and it established the Supreme Court as the chief interpreter of the Constitution. And so this has been an abiding principle for well over 200 years in U.S. jurisprudence, and it's been taken as an example in other places around the world.
And that's why the time factor of 200 years is something, in terms of how such a principle developed is really fascinating to understand the U.S. Constitution. But coming to the role of the Supreme Court, it's, one understands that the court takes up to maybe 150 to 200 cases a year out of large numbers that come to it. And is there any process? I mean, they obviously follow a process, but is there a particular way in which they decide what can come before it?
Sure. There are a few cases that can come before the Supreme Court by right, but most of the cases come out of the lower courts, the appellate courts, and on a petition of certiorari.
What is certiorari understood?
Oh, well, I've used the term writ of certiorari, which is just a fancy way of saying that the petition from a litigant to the Supreme Court asking the court to take the case. And then the court decides on that writ whether or not to take the case. So it's basically just a request to the court to consider the particular case, which the court will then review the petition and determine whether it wants to take the case or not. They generally will take a case that involves an important constitutional principle or a conflict between the lower courts on the interpretation of a constitutional principle. So in that way, really only the most important constitutional cases get reviewed by the Supreme Court. And there are many cases where they're quite content to let a lower court ruling or interpretation stand if they don't think that there's a constitutional principle that needs further review.
Could you tell us at least some of the landmark cases? I mean, what actually led to them?
The Supreme Court has a leading role in interpreting the Constitution and telling what this means. The United States Constitution is actually a fairly short document, very spare in its language, but enunciating general principles, both in the main body of the Constitution and also in the amendments to the Constitution. The first 10 amendments to the Constitution were what we call the Bill of Rights, and they establish many important principles of individual protections under that Constitution. But they're written in fairly straightforward but plain language, written in a way of stating principles that need to be interpreted over time and applied to the facts of the time as the times have changed. So this gives the court sort of broad authority but an important role in giving life to these principles. There have been many famous Supreme Court cases, U.S. Supreme Court cases over the years, but a couple of them stand out for the way they establish important abiding principles. One I would point to comes from the 1950s, and this was a case called Brown versus Board of Education. In that case, a young woman, an African-American young woman, had been denied admission into a public school because of laws regarding segregation of the races in public education. The Supreme Court took on this case and in a unanimous decision ruled that such segregation was inappropriate, was unconstitutional. They stated that separate educational facilities for the races were inherently unequal, and that laws requiring or permitting racial segregation in public education violated the equal protection of the laws. So again, giving life to this principle of equal protection of law, which is stated in amendments to the Constitution. Laws requiring or permitting segregation were unconstitutional. And so this was a landmark ruling that was then applied in other contexts for equal protection of laws for all citizens of the United States.
You know, one of the other judgments which from a criminal lawyer point of view, at least to me, has been the development of the Miranda doctrine. And the doctrine, of course, you know, has also been made very popular. If anybody were to see a American movie, because every time they arrest, you know, you have the police telling the accused that you have a right to remain silent. But this also has obviously developed from the judgment of the Supreme Court. Yeah,
that's right. It's a famous case, Miranda versus Arizona, which involved a suspect who had been arrested and then interrogated, and the determination that he didn't know, he wasn't aware of the rights that he had. And under our Constitution, he had a right to remain silent, and he had a right to be represented by an attorney during any questioning. And so the court decided that unless the individual knows those rights would be meaningless. And so hence the court established this principle of having to inform a suspect prior to questioning of his rights. And that's where you get the famous warnings that are you see in movies or television police shows, that any suspect has a right to hear this warning and be aware of his rights before any questioning, so that his response to questions are truly voluntary and gives credibility to any information then obtained in the questioning.
Especially in the context of self-incrimination, I would think.
Correct.
Right? So that there is a protection offered to him or her in that way. I just want to go back a bit into the history of the way the Constitution evolved and what went into it. And one aspect has been how, you know, the framers of the Constitution actually worked towards getting an opinion.
Sure. The Constitutional Convention, which put together this draft that contained many compromises, contained structural separation of powers, but they still had to have it ratified by the states in order for it to take effect. And there were many in the country who opposed this idea of a strong central government. They feared that a central government, a national government, was a threat to individual liberty. And so, following the acceptance of this draft and submitting it to the states for ratification, there was quite a public campaign. James Madison, Alexander Hamilton, and John Jay wrote a series of essays in support of this Constitution, in support of this kind of representational government. There were 85 essays altogether, and we now call them the Federalist Papers. But at the time, they were published in newspapers around the country and widely read. And we see them as a remarkable set of works of political philosophy and arguing in favor of the principles of this Constitution. And so following the Constitutional Convention, following the public debate, eventually 9 states adopted the Constitution, which was enough for it to come into force. And within a year, the remaining states also adopted the Constitution, along with, in the following year, the first 10 amendments to that Constitution, which we now call the Bill of Rights. And these were 10 amendments that protected individual liberties specifically under this new Constitution.
That assuaged a lot of fears, I would think, in terms of guaranteeing, rights to citizens. Yeah? But going a little more back into history, it's interesting, isn't it, that America was fighting the British and the treaty was signed in Paris.
Yes. The 13 colonies in the American Revolution had support from foreign powers, including France and Spain during the Revolutionary War. And France really was a main ally of the American colonies in that war and participated in some decisive battles of the American Revolution. And so then the negotiations for ending the war, ending the hostilities, took place in Paris. And hence the signing of that treaty in 1783, it became known as the Treaty of Paris to Americans.
Also, you know, the fact that the initial amendments came in the very beginning when the Constitution was formed, the US Constitution has had very few amendments. And I think, I mean, you know, it would be interesting for us to know the process of amendments to the Constitution that makes it so few.
Mm-hmm.
So, can you share with
No,
us?
you're right. The Constitution has only been amended 27 times, or there are 27 amendments to the Constitution over a period of more than 230 years. So it's been a remarkably stable and flexible document. The procedure for amending the Constitution is fairly straightforward. You need the Congress, both houses of the Congress, to pass a proposed amendment. And then that proposed amendment needs to be ratified by 3/4 of the states. And so there have been a number of proposed amendments that were never ratified. Some were time-bound and expired. But there have been 27, including the first 10, the Bill of Rights, which have been passed over the years. There's another way to amend the Constitution that's never been tried, and that's for a percentage of the states to call for a new constitutional convention. But that hasn't happened. The amendments have sometimes clarified procedures or established certain principles and rights over the years. Significant among these amendments were what we call the Civil War amendments, when the United States fought a civil war in the 1860s, largely over the question of slavery. And so the 13th Amendment abolished slavery. The 14th Amendment extended rights of due process and equal protection and citizenship to all of the states, for all of the citizens. And then the 15th Amendment guaranteed the right to vote regardless of race. We're now in June 2019, and this marks a very important anniversary in constitutional amendments. It was 100 years ago this month that Congress passed the 19th Amendment, which guaranteed the right to vote for women. And so it was in the following year, in 1920, that the last necessary state ratified it, and it became the law of the land. But this was, only 100 years ago that right to vote for women was established across all of the states in the United States.
Has there been other interesting amendments that have happened to the US Constitution?
Sure. Some of the amendments have been purely technical in nature, while others have made for significant changes. For example, direct election of senators, as opposed to having senators chosen by the state legislatures, came about. Or lowering the voting age for all citizens to 18 years of age. One of the most infamous amendments was prohibition, which banned the sale of liquor and alcoholic beverages, which after some time, a few years, found was not a successful amendment, and it was promptly repealed in the 1930s.
On the issue of due process, a lot of the criminal law cases, of course we did discuss Miranda. Has there been any other situations where the concept of due process has evolved? Because it's a doctrine that has evolved in the US. Yeah? And
yes. It's the doctrine of due process encompasses a number of basic rights and procedures in the criminal realm and in the general human rights realm. for example, written into the basic Constitution are prohibitions on ex post facto laws, or bills of attainder, or cruel and unusual punishments is in the Eighth Amendment. And these are all part of the structure of due process that protects an individual. And the concept has grown over the years, even to some substantive elements of due process, which have been cited by the Supreme Court in cases that have extended individual rights over the years.
So, and when you say ex post facto laws, you're saying retrospective, right?
Yes. Yes, Congress cannot pass a law
that can have a retrospective effect on citizens.
on citizens. Right.
I think we've had a very fascinating discussion where I would say we have really gone on a whirlwind tour looking at the US Constitution and what are the rights that it has guaranteed to its citizens that has really stood the test of time. So thank you very much, sir.
Thank you.
Welcome back. In this video, we shared a historical look at the US Constitution, which was created for the people and by the people. We also looked at how the Supreme Court and its decisions help shape the legal systems in both the United States and here in India. Thank you for watching, and click here for more videos on the US Constitution.